I'll examine that because for your information, the government is extending the date till 12th.
Please, Manoj.
So till 12th, right?
It is general. not
Generally, for
specific to
all,
this.
for all. So these orders, I'll pass it tomorrow morning. Let me consider. I'll pass it tomorrow.
But we have-
whereas notifications dated 23rd August 2010 and 29th of July 2011 specifically refer to powers conferred on the section 1 of 23 or 1 of the RTI. NCT recognition order dated 22nd of September refers only to the directive issued by the MHRD under section 29 of the NCT Act. It is it is thus clear that the entire scheme was for the purpose of providing a window to the in-service teachers, inasmuch unless they would have acquired the requisite qualifications prior to 1st of April 2019, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that the High Court has erred in holding that the 18 months diploma conducted by NIS through ODL mode is equivalent to 2 years diploma as provided in the notifications of NCT dated 23rd of August and 29th of July.
So what your contention with regard to that equivalence,
Yes.
gone. It comes further, it further discusses that.
No, Malak. Today, Malak, I'm on this submission, this strand is slightly different and vastly different. What I'm saying is the court also recognizes, what does it say? It says for in-service and in-training teachers who are already in employment. So it can be employment which is private, government, non-government, whatever. We are giving them this window that by 2019 you will acquire this.
I think that plea that you are trying, let's get off with this equivalence part. 45 and 46, 47 settles that.
Yeah, and 51 also, because what 51 says is that it could have issued. I agree, I'm one with your lordship. In fact, when your lordship is on equivalence, your lordship may come to 51. So may 50 and 51, because again, that one-time window is very important. So this is very important because what I'm saying is, my first submission which I made, that once I have acquired the qualification at paragraph 50 again, as already discussed here and above, NCT recognition order dated 22nd of September 2072 was issued so as to give effect to the directives of MHRD dated 8th of September so as to provide a one-time window to the teachers who are already working and who in terms of the 2017 Amendment Act were required to acquire the minimum qualifications prior to 1st of April 2019. So if they acquired the minimum qualifications prior to 2019, then how can they be non-suited?
Please read the last line also. The said order.
The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention of the 2012 service rules and the advertisement issued on the basis of such service rules. I will come to Uttarakhand. The Uttarakhand rule has a 2-year stipulation which is not there in the MIT. Now, paragraph 51, if your lordships may come. This is where your lordships, because since may I read this? What your lordships have said, is reflected here. We further find that the finding of the High Court that the 18 months D.el.ed diploma ODL course in elementary education conducted by NIOS is equal to 2 years diploma is erroneous. Therefore, there is no notification to that effect issued by NCT in supersession of its notification dated 23rd of August 2010 and 29th of July 2011, wherein it provides a minimum of 2 years diploma as a minimum qualification for appointment of teacher. At the cost of repetition, we clarify that the notifications dated 23rd of August 2010 and 29th of July 2011 were issued in exercise of its powers conferred under section 23(1) of the RTI Act, whereas recognition order dated 22nd of September was passed in pursuant to the direction issued by the MHRD under section 29 of the NCT Act. So now I'll take your lordship now to the last two, paragraph 53. And now your lordship may come to paragraph 53, and now your lordship will come to 56.
56.
In view of what has been held by this court here above, we find that the High Court erred in holding that the 18 months diploma conducted by NIS through ODL mode is equivalent to the 2 years regular diploma, particularly so when there was no material placed on record to even remotely hold that such a notification was recommended by the expert body NCT. I have no quarrel with this proposition. I am agreeing with you. On the contrary, the communication dated 6 September 2019, the directives of MHRD are so as the recognition order dated 22nd of September 2017 clearly go on to show that the 18-month diploma was provided as a one-time window to the in-service teachers to acquire the minimum qualification material and the outer limit of 1st of April 2019. In our considered view, the High Court has totally erred in holding that the 2 years diploma is equivalent to 18 months degree. Now your lordship come to paragraph 57, last sentence. They reiterate that, as already discussed, the last sentence of paragraph 57, as already discussed here and above, recognition order dated 22nd of September only provides a window for in-service teachers to complete their course prior to 1st of April 2019. So now, Malak, your lordship will come back to paragraph 31 where section 23 is enacted. So what does it mean? It means that No, you'll actually come back to qualification.
257, yes.
Yes. I'm sorry, I should have been your 23. Qualifications for appointment and terms and conditions of service of teachers. Any person possessing such minimum qualifications laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. That's one. Here, NCT is the authority, the regulation, the notifications are there. Subsection 2, where a state does not have adequate institution offering courses or training in teacher education, or teachers possessing minimum qualification laid down under subsection 1 are not available in sufficient number, central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment of teacher. Yeah. Now proviso 2, which is the proviso in question. Second proviso.
Provided further.
Provided further. Now this is very important. That every teacher appointed on or in a position before 31st of March 2015 who does not possess minimum qualifications laid down under subsection 1 shall acquire such minimum qualification. The Supreme Court finding also that I have acquired a minimum qualification within a period of 4 years from the date of commencement of the Right to Children to Free Compulsory Education Act. This is retrospective. So from 31st of March 2015.
I got it, Mr. Adhik. I got it. What is your submission with the relief you want in this petition?
Today, my submission, the relief today I see is that the advertisement have to be set aside. Because as far as there are 3 submissions that I have. In terms of the first submission, they are notified that disqualification has to go because it's a complete misreading. I have acquired minimum qualification. This is the Supreme Court finding in paragraph 55 and 56, penultimate paragraphs, and the ultimate paragraph. I have the qualification, minimum qualification in terms of section 23. So the advertisement has to be stated, and I have to be directed to participate in the selection process. 1. 2, as far as the equivalence part is concerned, in case your lordships is of the view that that equivalence is not there, and the Supreme Court has observed, the way out has also been provided by the Supreme Court in paragraph 51. NCT has issued recognition, has issued regulations. It is their stated stand. So it is now in requirement of their statutory duty under section 23(1) to mandamus can be issued on the basis of the judgment that you issue a circular specifying equivalence, because you have already said that's the minimum qualification. 3, the Assam rule, which is at page 89, Assam rule, which is at page 89, because your lordship does not have the prohibition of Uttarakhand. Assam rules adopts 23rd of August, and what is more importantly, your lordship will just have it's at page 89 extract.
I've got it. The RTE rules.
Please, the minimum qualifications for a person to be eligible for appointment as a teacher in elementary schools shall be notified by the National Council of Teacher Education number so dated 23rd of August, which is the 2-year. Now, the second part is very important. The provisions of all rules, notifications, orders of the government prescribing qualifications for teacher, which are repugnant to the stipulations laid down, laid down by the National Council for Teacher Education stands superseded. So today, the 22nd of September 2017, which are the recognition order, is an NCT stipulation. So how can the Assam?
Mr. Hazarika, I'm not sure whether you have been brought to your notice. We have another rule specifically for the service wherein the advertisement has been issued.
Yes.
You have a manual, this manual.
Please,
it's called the Assam Elementary Education Provincialization Rules 1977.
Yes,
and the provisions of Rule 3. B, C, B, down below. I'll just read it for you. The minimum qualification of a person to be eligible for appointment as a teacher in an elementary school shall be as per notification issued by the state government from time to time in conformity with NCT norms. These qualifications shall be applied to all category of elementary schools. So the rule says NCT, and you are developing an argument that that stipulation with regard to that 18 months is also inbuilt there, and until unless you don't exclude that from your rules, you cannot prevent these people from.
And my lord, they have acted upon it. Because 2019,
19,
2021,
they acted upon it.
2023, they have acted upon it. So many of and today, my lord, 100.
We'll hear the AG on that point. Yes, Mr. Second.
Yes, Lordship, I fully agree what my learned friend had just said, that 2019-20, we do it. Lordship was a
There
part
is no
of that
estoppel against
litigation.
you.
That litigation is still pending. But now
There is
with
no
the
estoppel
recent
against you.
Supreme Court judgment, Lordship, there is absolutely no ambiguity. It is very clear. Paragraph 51, paragraph 40 onwards, and paragraph 31 and 33. What remains, Lordship? We cannot violate the Supreme Court's order.
Now, Mr. Hazarika wants this court to issue a mandamus to the NCT authorities for incorporation of that in that rules, in that regulations. What do you have to submit on that?
On that, the Supreme Court has also said that till now NCT has not done anything.
So when the Supreme Court has not done
Anything,
should
how can this
court-
honorable
No,
court
no,
would-
address me on that. Should this court come in?
Absolutely no. This will be clear violation and in conflict of the Supreme Court judgment. Had there been any scope in the Supreme Court judgment, Lordship, that scope would have been there. But there is no doubt or any confusion regarding the language used by the Honorable Supreme Court, especially paragraph 51. Let us start from paragraph 40, Lordship. These are findings. What my learned friend was placing, basically those were arguments.
Mr. Soikia, you can come straight to 45, 46. I think
45
that is.
Lordship. 40, 41, 42, 42,
I've seen, I've gone
45.
through it.
Yes, Lordship, I am not repeating. 45.
45.
In the impugned judgment and order, the High Court has relied on the judgment of the High Court of Patna in the case of Sanjay Kumar Yadav and High Court of Tripura in the case of Raju Nama. It is to be noted in the judgment of the High Court of Patna, though a reference has been made to the communications addressed by NCT to the Additional Chief Secretary Bihar, it brushed aside the said communication on the ground that it is nowhere mentioned that the said course cannot be treated at par with the 2 years training course. In the absence of specific order of NCT granting equivalence to the 18 months course with 2 years course, in our view, the High Court has totally erred in finding that since the communication does not mention non-equivalence, it would be deemed to be equivalent.
You
In
took care of
fact, in the earlier 2 rounds,
46 will clear.
46, we find that the High Court of Patna has totally erred in not giving effect to the stand of NCT. As a matter of fact, we fail to understand as to why NCT did not challenge the said order when its specific stand that the said 18 months course was only for in-service candidate and not applicable to fresh ones was rejected by the High Court. We also fail to understand as to why communication dated 6 January 2021, NCT decided to accept the said judgment of the High Court of Patna.
47.
47. Insofar as the High Court of Tripura is concerned, it again relies on the judgment of the High Court of Patna in the case of Sanjay Kumar Yadav. We therefore find that the views taken by both the High Courts of Patna and Tripura were not correct in law. What remains, Lordship, thereafter? And paragraph 51.
The submission, Mr. Hazarika, you are making with regard to a mandamus to the NCT, that cannot be issued today. That we'll have to hear the NCT first.
Yeah, no, yes,
So
no.
today only we can consider whether we have to permit you
To participate
in
in
terms of that advertisement and the rule position read in the light of the decision of the Supreme Court. That's all.
Yeah, so my
That extent only. The
Mm,
other part can come in once the matter is finally considered after hearing NCT.
I'm in entire agreement. No, but I may say, and in all respect, because firstly, the rule, what my learned friend was referring to because the Supreme Court at paragraph 53 has said that it did not that the High Court of Uttarakhand erred because because there was no challenge to the rule position over there also. So, today my submission would be therefore, as far as
that Mr. Subject to correction is only an approach with regard to one of the contentions raised.
please.
The Supreme Court gave its verdict in paragraph 46, 47.
Yes.
Because I'm again reiterating, this thing you just cleared to me.
No, but it also
As I have read, NCT never said these two to be equal. It was for the first time that the Patna High Court said both are equal, do it. The Supreme Court saying that is bad law.
Therefore, my submission was because today, what is the because eventually it is the ultimate and the penultimate paragraphs of the Supreme. The Supreme Court says in paragraph 56 and 57 that you have acquired the minimum qualification in terms of Section 23. That if I have acquired the minimum qualifications in terms of
Okay. Let's test that. Let's
Yes,
test that.
very well.
Let's test that argument. If that was the intention of the Supreme Court, why did it interfere with the judgment of the Uttarakhand High Court and did not pass an order to the NCTE to incorporate that?
Because the Supreme Court, at paragraph 43 made a distinction between, I think paragraph 43 made a distinction that it is not for fresh, that for fresh appointment it cannot happen.
This is fresh appointment, Mr. Hazarika. You are not a appointee under the government or in a school appointed in terms of norms of the government. You may be anywhere. You may be a private institution, individual. You may be a contractual work employee with the, or an ad hoc employee with the government. But you don't have a root in the government service.
So may I just, let's look at it the other way around. What is the implication of this judgment? The implication of this judgment that this 18-month course is a valid minimum qualification in terms of Section 23.
Yes.
Now, therefore, if I have a valid minimum qualification in terms of Section 23, does it mean, what is the implication? The implication that I can not only continue to be employed in my present position, I can also be employed elsewhere.
That's the catch. That's the catch.
It isn't the catch.
That's the catch. If you come to the
cannot be.
decision of the Supreme Court, here, it has categorically said
Fresh appointment. Fresh appointment
it will not
hasn't-
appoint to fresh appointees.
No, so
No,
fresh-
Mr.
I
Just try to factor in this also in your argument. This 18 months was only to get the teachers across the country who did not have the minimum qualification with regard to RTE achieve that. This was a student-centric approach of the government. It was nothing to do with the teachers. It was a student-centric approach so that the students are not deprived of a proper education from a trained person. Now, keeping that view in the mind, as far as I have understood, the Supreme Court had proceeded.
So
What do you have to say?
2 minutes. So my first submission.
I'm
on-
examining this only with the view whether I should permit you to appear in the elections.
I'm grateful. As far as permitting me to appear in this whole process, as I said, let me address this query of yours, Lordships. Today, if I have that's what falls from your Lordship is that this being a student-centric thing may have been the perspective, but in terms of the statute, in terms of Section 23, I have the minimum qualification. Having acquired the so fresh appointment would mean, because why it also is, and I think that is because it says that the 6 months internship is subsumed in that 18 months.
Why?
Because I'm an in-service teacher.
No,
Yes.
Mr. Hazarika, you read it further. It was because that time was not there.
No, very well.
Cut-off date to come into operation.
No.
Only 18 months were left. It went ahead.
So regardless of that, today the court has held that I have the minimum qualification. Penultimate paragraph, it says twice, and that was what I wanted to read to you all. It says I have the minimum qualification. If I have the minimum qualification Section 23 as a teacher in terms of Section 23, and I'm eligible to continue as a teacher in my school, why can I not get? It says fresh appointment. What the Supreme Court meant was a fresh appointment in terms of someone who was not in training. So that is why it said this is a separate class. That is what the paragraph 1. 2 minutes as far as the facts are
I got your
concerned.
point. I got your point.
As far as the facts are concerned, all along the Assam government, the central government, everyone, MHRD, all of them have today 2019, 21, 23, I have been recruited. Now, and Supreme Court in paragraph 51, I have also provided the way.
Got it. So you mean to say that the Supreme Court judgment has not considered that effect of 23 proviso.
Yes.
So it's per inquiry. I'll have to declare it per inquiry.
No, it is not. Because the Supreme Court has not said that they are not.
Did not.
Did not say that they would.
This
But
direction
no,
ratio is binding on me.
No, what it meant in terms of fresh appointment was someone who was not in service. Today in service means someone can be in service in a private school.
No, the advertisement says any person in government service in an LP school cannot apply. You got it. We will examine. Don't worry. We'll examine.
Well, at least permit me to will also participate in the process because well, after all, we are.
I'll examine that because for your information, the government is extending the date till 12th.
Please, Manoj.
So till 12th, right?
For it is general. not
Generally, for all,
specific to
for all,
this.
for all. So these orders, I'll pass it tomorrow morning. Let me consider. I'll pass it tomorrow morning.
But we have serious objections because we do not want to do anything in
I have
piecemeal.
understood your objections. Mr.
My objection is for any kind of interim order. Lordship may be pleased to issue notice. We have
Will do.
noted out. Paragraph 51 very clearly takes care of section 23, section 29, and as well as all the notifications. And also whatever has Lordship has regarding the 1977 rules.
293.
We cannot
Go beyond.
violate that. We cannot violate that.
Because I had a doubt first.
Till date,
As Mr. Hazarika is trying to project, has to build up a case, that there was a rule with the Uttarakhand government. That rule was violated, and the High Court Supreme Court has made some observation in that line also. I was in doubt as to I did not know that this provision was added. While consulting the book, I got we are in a better the state. I think has put itself with NCT.
yes.
Yes.
Or with NCT.
The recognition order is a statutory
And
order.
Lordship, paragraph 53, last line.
Okay.
The High Court, in our view, if it is respect of the other cases, the High Court, in our view, could not have issued such a mandamus contrary to such service rules.
Yeah, that is Mr. Hazarika is also trying to take, but that was one of the limp of the arguments. The
And paragraph
exact
51 very clearly refers about the
exact-
notifications.
exact nerve of this judgment is paragraph 45, 46, and 47.
Yes, Lord.
Because other than Patna High
And the contemporaneous records in paragraph 51.
we'll try.
Grateful.
Let's see how best we can help you.
And
I am
in 19, 20, 21, we did it because till that time, the Uttarakhand judgment was not there. We are with Hazarika, but today we cannot.
No, Manoj,
The Supreme Court
It is
has-
up
That's
to
why
the
my
ethical
opening,
judge.
opening liner was, I am
But-
supporting him, but today I cannot.
You cannot.
My learned friend Manoj only has to construe the judgment as the Advocate General in terms of the manner in which it is given. But in paragraph 56 and 57, that's enough. He says, I'm
The
qualified.
problem, Mr. Hazarika, I am facing.
The irony is that when my Lord Justice Nair was on the other side, we always saw the Patna High Court and Tripura High Court against him.
This was the argument maybe I could have done. Let me consider. Tomorrow morning, 10:30.
I am grateful, Manoj.
Highly of this.
At least I was the delivery of order. I'll not dispose of the writ petition. I'll only consider the interim and issue a notice. Okay?
We are right.